What's the difference between having a will and a living trust? A will is a legal document that describes how your assets should be distributed in the event of death. The actual distribution, however, is controlled by a legal process called probate, which is Latin for prove the will. Upon your death, the will becomes a public document available for inspection by all comers. And once your will enters the probate process, it's no longer controlled by your family, but by the court and probate attorneys. Probate can be cumbersome, time-consuming, expensive, and emotionally traumatic during a family's time of grief and vulnerability. Con artists and others with less than pure financial motives have been known to use their knowledge about the contents of a will to prey on survivors. A living trust avoids probate because your property is owned by the trust. So technically, there's nothing for the probate courts to administer. Whomever you name as your successor trustee gains control of your assets and distributes them exactly according to your instructions. There is one other crucial difference. A will doesn't take effect until your death and is therefore no help to you during lifetime planning, an increasingly important consideration since Americans are now living longer. A living trust can help you preserve your estate while you're alive and offer protections should you become mentally disabled. Can any attorney create a living trust? Yes, but you would be better off choosing an attorney whose practice is focused on estate planning. Members of the American Academy of Estate Planning Attorneys receive continuing education on the latest changes in laws affecting estate planning, allowing them to stay on top of the latest laws and techniques to help you meet your needs. If I set up a living trust, can I be my own trustee? Yes. In fact, people who create most living trusts act as their own trustees. If you are married, you and your spouse can act as co-trustees, and you will have absolute and complete control over all the assets in your trust. In the event of a mentally disabling condition, your hand-picked successor trustee, not the court's appointee, assumes control over your affairs. Can I transfer real estate into a living trust? Yes. In fact, all real estate should be transferred into your living trust. Otherwise, upon your death, depending on how you hold the title, there will be a death probate in every state in which you hold real property. When your real property is owned by your living trust, there is no probate anywhere. Will a living trust avoid income taxes? No. The purpose of creating a living trust is to avoid living probate, also known as conservatorship, and also avoid death probate, and reduce and even eliminate federal estate taxes. It is not a vehicle for reducing income taxes. In fact, if you're the trustee of your living trust, you will file your income tax returns exactly as you filed them before the trust existed. There are no new returns to file and no new liabilities are created. Is the living trust some kind of loophole the government will eventually close down? No. The living trust has been authorized by the law for centuries. The government really has no interest in making you or your family suffer a probate that will only further clog up the legal system. A living trust avoids probate so that your estate is settled exactly according to your wishes. Isn't a living trust only for the rich? No. A living trust can help anyone protect his or her family from unnecessary probate fees, attorney's fees, court costs, and federal estate taxes. In certain circumstances, even individuals with small estates can derive meaningful benefits. Thank you for watching our video. We encourage you to subscribe to our YouTube channel for more FAQ videos about estate planning, probate, trust administration, and medi-cal asset planning. For more information on these topics, register for one of our upcoming webinars by clicking the registration link in the description below. See a full list of webinar dates and times by visiting our website at www.losangelestrustlaw.com or calling our office at 626-403-2292.